Hi, I'm Mark Mifflin. I'm a member of the Illinois Defense Council Legislative Committee, and I'm here to provide you a very brief update about the spring session of the Illinois Legislature, which ended on May 23rd of this year. It's June 4th when I'm giving this report. The spring session was scheduled from January through May, but they did not do much work before the primary election in March. Then when they started to come back to work in March, of course, is when the COVID-19 crisis arose, and they were not able to come back during the months that they expected to. So what they did was they had a truncated session, a very short session from May 20th to May 23rd, in which they addressed necessary matters. And I know that necessary is in the eye of the beholder, and it's not clear what qualifies under anybody's definition of that, but they really did limit the issues that they brought up. They were primarily budget issues and the COVID issues in terms of the powers of the governor and the requirements of the public and of employers and businesses to comply. They also did some Medicaid funding and some other issues which needed to be done. But the most important thing for the Illinois Defense Council was House Bill 2455. This is a workers' compensation bill. Particularly, it was Senate Amendment 2, if you're looking this up online. Or if I think it's going to be any time now, it's going to be put in the enrolled fashion. If you find that on the website, that's the part which will be sent to the governor, so you can read it in the enrolled version. That's what you have. And what this arose out of an aborted effort by the governor and the Work Comp Commission to create a rule and enforce a rule dealing with much the same thing, an enforcement of a presumption of liability for the employer if an employee is diagnosed with the COVID-19 disease. The rule was a temporary restraining order was entered to prevent the enforcement of the rule. The judge indicated that he did not believe that Governor Pritzker or the Work Comp Commission had the authority to do that because it was a change in the law. So the effort was sent back to the Work Comp Commission, and at that point they abandoned the rule, withdrew it from the Joint Committee on Administrative Rules, and began in earnest in the legislature once again when the legislature came back at the end of May. It returned on May 20th and was here till May 23rd, so you can see it was really a short session. This presumption is created by the new bill, by the act. It will become the act. The governor is expected to sign it any day. Creates a rebuttable presumption of causation for essential employees. And essential employees are very broadly defined, as they had been broadly defined in the rule that the governor created, which was aborted. But it's a lot, very, very broad. It's not only first responders or frontline workers like medical people. It's all of the essential workers that were defined by the governor's order. So it is very broadly defined. I want to point out to you, this is not in the legislation, but it was in the legislative intent that was read on the floor of the General Assembly when the bill was passed. The rebuttable presumption is a quote, ordinary presumption. And the ordinary is defined in the case Johnston versus Illinois Workers' Compensation Commission in the context of a different rule or a different statute that says it's rebuttable by any evidence from the employer that there was another cause of the disease. And I want to point this out because it could have a very big effect. The trial lawyers and labor wanted, in discussions about this bill, wanted there to be a clear and convincing evidence standard for employers to rebut the presumption. But that was rejected by the legislature, and the presumption is an ordinary presumption which can be and will be rebutted by any evidence from the employer. And some of the issues that you can use to rebut the presumption is if they were working at home, if the employee was working at home, if the employer practiced best practices as defined by the CDC or the Illinois Department of Public Health, if there were other sources of exposure for the employee, and there are several other that are listed in the bill, which you can see. So it's a presumption, and certainly that's not a good idea, but there are factors in the statute to enable an employer to rebut that presumption if there's any evidence available to do that. And I understand, and the legislature understands, that sometimes the employer may not have access to that type of factual information. But that really, the legislative climate right now with the trial lawyers and labor so powerful with the Democratic legislature and governor did not give the employer community much effort to, or much way leeway to negotiate this. And by the way, this was negotiated by the Illinois Manufacturers Association and the Illinois Retail Merchants Association. And the insurance industry supported them, the Defense Council supported them. So it was a broad effort among the business and employer community to see what we could do and to address this the best way possible. Another bill that may be of significance to us in the future is Senate Bill 2135. That deal creates a task force to study the issue of business interruption insurance. There was initial effort when the COVID-19 crisis developed to require insurers to cover business interruption issues and costs, even though the insurance policies 99% of the time exclude those types of damages. That when it was determined how much that would cost, and of course no premium had been collected for that, it was decided that instead they would create this task force that will work with the Illinois Department of Insurance and report back by the end of the year as to how this can be handled, and particularly how it can be handled in the future. And it may involve the creation of a state fund to address this in the future, those types of issues. And of course the funding for a state fund could be critical too. So that's another thing we'll want to watch for, both for our insurance company clients and for our employer clients. So watch for that one. There was one new bill that was filed now too during the session, House Bill 5769. That was filed by Representative Andre Tapetti from Chicago. It's probably another trial lawyer initiative. It did not proceed in the truncated session, but it is likely to come up again in the veto session or next year. The veto session, by the way, will be held from November 17, 18, and 19, and December 1, 2, and 3 of 2020. So it's a limited session. It's also a limited session. It's not expected that the legislature will try to get involved in all the substantive issues which they missed out in the spring. More likely, they'll wait. They could do some of them in January before the new legislature is sworn in. But more likely, most of those issues will wait until next year when the new legislature is sworn in January, following the November election. So this bill, House Bill 5769, is not a good bill. It would require an employer to provide personal protective equipment to all of their employees in order to avoid a lawsuit if the employee does develop the COVID disease or any similar disease, frankly. The biggest problem, of course, is it creates a direct cause of action from the employee to the employer in court, which abrogates the work comp exclusive remedy provision, long-standing provision and linchpin of the work comp law. It's very broad. It applies to employers and to independent contractors. It allows for punitive damages and attorney's fees if the plaintiff recovers. So it's very broad and very bad. Now, I'm not sure how this is going to develop whenever it comes up, probably in January. But it is expected that they will continue to raise this. And again, this is the second attack on the exclusive remedy provision by the trial lawyers in 2 years. So this is not a good sign. There is a one-page paper that the Illinois Defense Council created in opposition to this bill. Pat Eckler from Pretzel and Strofer created that. It's on the IDC website, and that explains the bill to you more. Or you can look at that bill online. It's very short. It's House Bill 5769. So those are the things that have come up since we last talked and since the COVID-19 crisis developed. We are continuing to watch the legislature. We are continuing to watch to see what's filed. We are continuing to work with any rules and regulations which are developed, which may now be developed in conjunction with the new statute, now that there's statutory authority. So the Illinois Defense Council will continue to watch those things for you, keep you advised. And certainly if you have any questions, you can check the website for the information that's posted there and the Illinois General Assembly website for that information. Or let us know if we can help you. That's what we're here for. Thank you very much.